Hello and welcome back to the video lecture series on the course of the Indian polity. And today I have an important announcement to make. First of all, we have been developing the WhatsApp community wherein we have different groups dedicated to the courses that we launch over the platform of Aayu Pathshala. So there is a dedicated group on Indian polity. The people who are viewing this course are requested to join that group so that you can share your doubt and can discuss the details on it. Also, we ensure to provide 24 cross 7 support for any student who are registered with us. For them, the 24 cross 7 solutions and doubt clearance is available on the WhatsApp community. Also, you see the link to the website ayuconsultancy.in. You can check out the details of the courses over there. And if you have any query, you can reach out to us directly on the WhatsApp number being displayed on the screen. So up till now, in the course of the Indian polity, we have covered part one and part two of the Indian Constitution, and this is most probably the eighth video in this series, and we have discussed a whole lot of things. It is always favorable to stop in the middle and just to recall all those things that we have completed so far. This will not only boost our memory, but will also make us fresh to what we have done so far. So let us now jump into our very first lecture on the revision. So this is the first revision lecture, and we will in the between of the ongoing video lectures of the on this course, we will try to bring on the revision lecture as well, so as to I know that most of you who are watching with us probably don't care to revise the thing that we have done so far, and it is a proven strategy that you, if you revise regularly, the very first revision would require a hell lot of time. But definitely, as the revision multiplies, the time taken to revise the things also get reduced. So in the previous video, we have completed till part 2. So up till that point, let us revise first, and then we will do some sort of previous MCQs on the topics, and then we will proceed further. So this is what we have done so far. That is, we have discussed what is the constitution, and we have discussed why it is called as the supreme law of the land and why this is required. We have also seen that there were such a discriminatory act that were in existence before the India had its own constitution. We have seen that Vernacular Press Act and the Arms Act were discriminatory in nature but still in existence. But as soon as the constitution came into existence, the discriminatory laws and the laws which does not pass the test of the Indian constitutions were struck down by the guider of the constitution, that is the Supreme Court, and we have seen how the adultery was struck down. Then we have seen the Cripps mission, and the very first time the Constituent Assembly to frame the Constitution of India was discussed in the Crisp mission, although the mission failed because it was an arrow in the air with no aim, just to gain the support of the Indians to fight, to support them, to cooperate with them during the Second World War. Then we have seen the cabinet mission, wherein the detail of the strength of the Constituent Assembly, how the members would be elected, and then the Constituent Assembly itself was formed, and the different session that has played, and the different factual data about the Constituent Assembly. Then we have seen the different committees and the chairman of the committees. Then we have seen the detail of the drafting committee, their members, and the members were dominated from the legal background, and then other factual details with respect to the Constituent Assembly we have discussed. So those who are not watched the previous video, go please watch that video. Sure, make yourself comfortable with the terms that we have cleared so far, and then proceed with the future videos. Over the overview of the Constitution, we have seen that the when the Constitution was framed, 395 articles were there, 22 parts were there, and 8 schedules were there. Later on, we have seen that the schedules were added, and the overall schedule as of now is 12. Then we have discussed the salient features and the criticism of the constitution, in which we have discussed the most salient and important features, and we have told that the other features, that is the parliamentary form of the government and the single citizenship and all, will come during the course of the video. And we have seen one of the features in the previous video, that is about the our constitution allows for the single citizenship. That is also one of the feature of the Indian constitution. Then we have seen the criticism of the constitution and how the Dr. B.R. Ambedkar answered to all the criticism, and did the criticism stood valid, or they were just a criticism on the makers of the constitution. Then we have seen the different sources from where the constitution is copied, and again this was one of the major criticism, that the constitution is copied from the various sources and had nothing to do with the originality of the Indian Constitution, to which Dr. B.R. Ambedkar said that the Constitution was a universal idea and it is nothing wrong in copying to something that is universal. So, what makes a book unique, what makes the Constitution unique, is its suitability with respect to the requirement of the people of the country. Then we started with the preamble, and we have seen why it is so important. How Dr. B.R. Ambedkar said that it is a political horoscope, and then we have seen the amendment of the preamble and the various cases associated with the judgment of the preamble to be the part of the Indian Constitution, and we have seen also the famous case of the Keshavananda Bharati case and its judgment with respect to amendment of the fundamental right and its the jurisdiction of Article 368, whether this includes the fundamental right or not. Then we have seen 13 clause 2, whether that 13 clause 2 is applicable to the amendment of the constitution, or is only applicable to the ordinary law passed by the parliament. That details we have already discussed. Then we started with the part 1 of the Indian constitution, that is the union and its territories, and we have gone in detail with the article number 1 to article number 4, wherein we have also discussed the Beriberi union case, specifically related to article 3 of part 1. And then we have seen the various committee, the demand of the people for the reorganization of the state on the linguistic lines, and we have seen the recommendation of the JVP committee, Dhar committee, and Fazl Ali committee on which was set up to check the feasibility of the reorganization of these states on the basis of the linguistic line. And we have also seen the recommendation of the Fazl Ali committee and the 4 points that he raised that should be kept in mind while we are organizing a state on the line of the language. Then we have seen the State Reorganization Act of 1956 and the status of the Indian territories on that day. Then we have covered the part 2, that is the citizenship, and we have understood comprehensively the background in which the citizenship was mandatory to be brought in, and the articles from article number 5, 6, 7, and 8, which specifically deals with the citizenship of the various categories of the people on the date of the commencement of the constitution. Then we have seen article 9, 10, and 11, which deals and is still relevant today in the modern day. And also we have seen that under article 11 the parliament has passed the act of citizenship act of 1955, which have been amended multiple number of times to regulate the citizenship post 1950. And within this we have seen two important amendment of 2015 and 2019. In 2015 we have seen the citizenship amendment act, and 2019 the latest one, in which the naturalization terms have been reduced to 5 years from 11 years. And then we have discussed the OCI cardholder details, the process of registration, who are eligible, how the renunciation and termination of OCI cardholder membership is done. So this is what we have discussed so far, and let us now move ahead and discuss two important features of the Indian Constitution. But before that, I was mentioning 2015, wherein we have the merger of the OCI and PIO scheme of Indian government into OCI cardholder scheme. So now let us move and discuss the two important features of the Indian Constitution. The first one is called the parliamentary system. and we will compare it with the presidential system that is being followed in the United States of America, and then the federal government versus the unitary government. Remember, the federal government is the salient features of the Indian Constitution, and the parliamentary system is also one among the salient features of the Indian Constitution. So, what is the parliamentary system? In the parliamentary system, we have discussed it so many times during the course of the lecture, but I thought it would be great to provide you the written notes so that you can copy it down and can reproduce it in the examination. So, the parliamentary system is a system in which there is a dual executive, there is a dual government, there is a dual executive, sorry. The one is called the nominal head or the nominal executive, which is the president, and then there is a real executive or the real head, which is the prime minister, along with the council of the minister. Then in the parliamentary system, there is a majority party rule. Majority party rules means those party who get the maximum number of vote, maximum number of seat in the house make the government. Then there is a collective responsibility, that is the council of minister is collectively responsible to the lower house, or we can say that the executive is responsible to the legislature. Then there is a political homogeneity, that is the ministers belonging from the same political party ensure uniform political thinking, and that is important for the formulation of any laws. Then there is a double membership, that this minister is the member of both the legislature and the executive, that is they also participate in the administration of the country, enforcement of the law, and they also participate in making of the laws as well. Then the prime ministerial leadership, that is the prime minister is the real head of the government. Then there is the dissolution of the lower house, that is Lok Sabha is dissolved and fresh election is held if the head of the state, that is the head of the cabinet, that is the prime minister resigns, or the executive loses confidence in the house. In both the case, the dissolution of the lower house takes place. Then there is a fusion of power, that is executive and legislature are closely connected. So, if the parliamentary system is asked and any of the above eight features is mentioned, that in the parliamentary system there is a dual executive, there is a majority power role, there is a collective responsibility, there is a dissolution of the lower house, or any of the any of the 8 points that have been discussed, then that should be marked as correct, because these are the features of the parliamentary system. And India, we see these all these features are applicable as per the Indian Constitution. We have the majority power rule as well, we have the political homogeneity as well, and we have the a double membership, that is the ministers who are the part of the executive or also the part of the legislature. So what would be the presidential system? The presidential system, would not be a dual executive. There is a single executive, that is the president, is both head of the state as well as the head of the government. There is no prime minister separately and president separately. There is a single president in the presidential system, and he is both the real and the nominal head of the state. Then there is a separate election. President and legislature are elected separately for a fixed term. Okay, that means if you go to the United States, the president election is held separately, but in India, president is elected indirectly. Then the other features of the presidential system, which is not important, I'll not be discussing all these details, but you can go through it if you want. What was important from the Indian Constitution point of view was the parliamentary system that I have discussed. Now let us discuss what are the drawback of the parliamentary system. The very first drawback that you can figure it out from here only, that is majority power party rule. That is, suppose if today one party is ruling and he makes some legislation, he made a law. Tomorrow he loses the confidence. So whatever law he made, the another party came to the majority. He forms the government, and he said that the laws that the previous party made has become null and void. So basically, there is instability. There is instability in the government, and there is discontinuity of the policy. This is one of the drawback of the majority party rule. For other drawback, let us go and let us see what are the demerit. There is an unstable government, there is lack of continuity of the policy, there is a weak separation of power and government by the amateurs. That is, minister may lack subject matter experience. For example, in the recent cases, we have seen that youngsters are made the ministers. The In the recent news, we have heard that a man become the minister with no experience. On being asked that you have made a minister without an experience, he said that ask my dad about it. I do not know. So such as the demerit of the a parliamentary system. So I am giving you these points because this point becomes very vital when you are writing the subjective questions in the examination. For objective, you can easily figure out from the options, but for subjective, you must at least know 7 8 points so that you can reproduce that in your answer sheet, and that would make your answer sheet not only beautiful but also worth getting marks. So demerit, we have seen. What are the merits of the parliamentary systems is that there is a harmony between the legislature and the executive. Why? Because there is a dual membership. I am the member of the executive as well. I am a member of the legislature as well. So there is exists a harmony between the executive and the legislature. There is a responsible government because always the executive is responsible to the legislature for the course of action, and they know that if today we lose the confidence of the legislature, then we will have to resign from the government. Also, it prevents despotism, that is executive power is checked by the legislature. Why? Because executive is always responsible to the legislature for their act of commission or omission. Then there is a wide representation, that is coalition government often include diverse social and regional voices. So I hope there is not much to explain in detail about the parliamentary system. Now let us move to the federal system. In the federal system, we have already discussed so many times that the federal system, there exists two separate government. No government interferes in their matter normally. But when the scenarios go bad, obviously the union is sitting at the center and is the strongest. So federal government, we have there is the distribution of power. We may say there is the independence of judiciary. These are the properties of the features of the federal government. There is a supremacy of the constitution, there is a written constitution, so all these are, there is a bicameralism. So these are all the features of the federal government. So let us see federal government versus unitary government. In federal government there is a dual government, that is the union government and the state government. Okay, the constitution is written, the power is clearly divided as we have in the separation of power in the schedule 7. Then supremacy of the constitution, that is parliament is not supreme, the constitution is supreme. Flexibility, that is constitution is rigid as well as the flexible. Independent judiciary to interpret and protect the constitution. We have seen various times the legislature interpret the constitution or as per their suitability, but the real interpreter is a judiciary which is not working for the government of India, but they are working independently. And legislature is usually bicameral, that is, there are the two houses, the upper house and the lower houses. On the other hand, the unitary government is a single central government. Regional bodies exist only if created by the national government. And the constitution may be written, for example, France, or maybe unwritten, example, Britain. In Britain, basically, the conventions were compiled, conventions. Today you adopt one convention, the next day you adopt one convention, and all these conventions are compiled into one book, which is called as the Constitution. The Constitution, as of India, were not written dedicatedly by a group of people and adopted entirely at one day. That was not the case. It is evolved day by day. Conventions are added up to form a constitution. That is called the unwritten constitution. Then the distribution of power is no constitutional division of power. All the power rests with the central government. And since the central government enjoys all the power, it is known as the unitary government. And supremacy of the constitution may or may not be supreme. For example, in Britain, we do not have constitution as the supreme. What we have is the Britain Parliament as supreme. Then, on the point of the flexibility or rigidity of the constitution, then since Indian constitution is a blend of flexibility as well as the rigidity, but the constitution under the unitary government may be rigid or may be flexible. Judiciary may be dependent or independent, that will depend. And maybe there would be, the legislature would be bicameral or unicameral, that is, there may be the lower house or the maybe lower house and upper house both. So I hope the federal government versus unitary government is easy, is self-explanatory and self-understandable. Although we have discussed the features so many times, but I have provided you in the written form. Now let us proceed and see what types of questions are expected, especially when we talk about the subjective nature of the question. So from the topic that we have discussed so far, I have tried to bring out few questions which are subjective in nature. Now, see, these questions, the answer to these questions will depend upon for which examination you are intended to write for. For example, for the UPSC, these word could be written as 150 to 200 words because the questions would be around 12 to 15 marks. But if we go to the state PCS, though these marks may vary from 25 to 35, and accordingly, all the details relevant to the question and a bit around it you can write. But if you this question is asked in the UPSC, so you have to write to the point. So what I will be doing that we will be providing you the model answer, but you write this answer first. You try to write this answer yourself, and then try to share your answer on the WhatsApp community where the other people, other student will also be sharing the answers, and you will be able to see their answers. You will be able to match your answer with their answer, and finally we'll be evaluating the copies shared by you and then share it back to you personally on your number. And also we will be uploading the model answers to these questions either on our website or on the WhatsApp community. So let us start with the first question, wherein the question asks that a constitution is not merely a legal document, but also a political and moral framework of the governance. Explain. So, in this question, the statement is given that constitution is not merely a legal document, but a political and a moral framework of governance. Explain. You have to first write the introductory para about the constitution, and then discuss the legal part of it, the legal part of the constitution, and then the political and the moral framework. Moral framework is been reflected by the directives policy of the principle of the state policy. And then we have the manner of election, different parts of the constitutions we have, which talk about the different aspect of the constitution. Moving to the question number two, we have the question is to discuss the composition, objectives. You have to discuss the composition, objectives, and key recommendation of cabinet mission plan. How did it shape the Constituent Assembly? Composition, who were the members of the Cabinet Mission Plan? We have three members. That is, who were the members? And then what was the objective? What was the recommendation? Straightforward question. Should not be any problem in writing the answer to it. Question number three, the success of Indian Constitution is largely attributed to the committees of the Constituent Assembly. Discuss the role of the drafting committee and other major committee of the Constituent Assembly. Again, a straightforward question to answer. Question number four, discuss the salient features of the Indian Constitution. In what ways has the Constitution been criticized as being too rigid and too flexible at the same time? Now, see, these questions that you are going to expect from the Indian polity will either be related to the current affairs or will be the static question. The current affair part of the question will be dealing separately when we start the current affairs series, but the static portion will be straightforward. Need not to think so much hard to make up the answer. The answer is automatically discussed so many times in the class. So directly you have to write whatever you get in your mind. So these questions are very straightforward. Question number five, discuss the significance of the preamble to the Indian Constitution. Examine whether it can be amended with reference to the key Supreme Court judgment. Again, a straightforward questions where you have to discuss the various judgment of the Supreme Court under the different cases such as the Berry Indian case, LIC India case, and the Keshwananda Bharti case, etc. Question number six, explain the relevance of Keshwananda Bharti case judgment. How did it define the doctrine of basic structure? Basic structure doctrine that you have to discuss. Background for the Keshwananda Bharti case you have to discuss. On what ground the case was registered, what Supreme Court observed, and why it is regarded as a constitutional landmark because it opened the gate. We have discussed that the Schedule 1 was introduced, Schedule 9 was introduced, and the blanket coverage to all the laws placed in it was given, but once the basic doctrine judicial review was put under the basic structure doctrine, and then that blanket protection to all the laws in the Schedule 9 was removed. So I hope you will sincerely write an answer to all these six questions and share it on our WhatsApp community so that we can evaluate your answers and can revert back to you. If you are serious with your preparations, you have to donate time. देखो मेहनत करोगे, डेडिकेशन के साथ लगे रहोगे, you will definitely do something, you will score good marks, and I ensure you, हम ये इंश्योर कर देते हैं आपको कि इंडियन पॉलिटी जितनी डेडिकेशन के साथ और जितने अच्छे तरीके से, जितने ज़्यादा क्लैरिटी के साथ आयु पाठशाला आपके लिए लेकर आ रहा है। आई होप, मैं मतलब ऐसे तो नहीं बोल सकता हूँ, चैलेंज नहीं कर सकता कि कोई नहीं लाएगा, लेकिन आप ही खुद ही मतलब यू try to compare the content that we are providing to you, the effort we are putting in, so that you qualify, you succeed. What we will get us is just we'll get the moral satisfaction that yes, what we are doing is helping someone else, what we are doing is worth of it. So now let us do some PYQs quickly, and this time we will proceed from the reverse direction. The concept of judicial review is in India has been adopted from the constitution of. Pause this video, try to solve it. I will take a pause before giving the answer so that you can correct your answer then and there. So the concept of judicial ratio is taken from the USA Constitution. The main advantage of the parliamentary form of the government is the executive and the legislature work independently. It provides continuity of the policy and is more efficient. This is the drawback. Does not provide the continuity, does not work independently. The executive remain responsible to the legislature. This is the correct answer. And see, the question has been asked in IAS previous prelims 2017. The Indian political system, which one is supreme? The supreme is the constitution and nothing else. There is a parliamentary system of government in India because the Lok Sabha is elected directly by the people. Parliament can amend the constitution. Rajya Sabha cannot be dissolved. Council of Ministers is responsible to the legislature. See, the name is changed. Sometimes the Council of Ministers is written, sometimes the executive is written, sometimes instead of legislature, Lok Sabha is written, but the answer remains the same. Asked in 2015, same question asked in 2017, but a little play with the terminology. So the parliamentary government is a system of democratic government in which members of executive are taken from the legislature and are accountable for the same. Therefore, the executive, that is the council of minister, is responsible to the Lok Sabha, that is House of the People. Next question: which one of the is the most prominent element of the state? Flag, capital, head of the state, or sovereignty? Sovereignty is the most prominent element of the state. Then which one of the following best define the term state? A community of person permanently occupying a definite territory, independent of external control and processing an organized government, a political organ. Option number B, a politically organized people of a definite territory and possessing authority to govern them, maintain law and order, protect their natural rights, and safeguard their means of sustenance. Option number C, a number of persons who have been living in a definite territory for a very long time with their own culture, tradition, and government. Option number D, a society permanently living in a definite territory with a central authority, an executive responsible for the central authority, and an independent judiciary. So the answer is, I would not be telling you the answer for this question. What you need to do is comment the answer yourself. This is a reasoning question. Just read it once and then try to answer. Then, how many type of justice, liberty, equality, and fraternity in order have been mentioned in the preamble of the Constitution? So, what we have: justice, liberty, equality, or fraternity. How many types of justice? Justice, social, economic, and political, three type. Liberty of thought, expression, belief, faith, and worship, five type. Equality of status and opportunity, two type. And fraternity. So, three, five, two, one would be the answer. Okay. What is the legal nature of the preamble of the Constitution? Is it enforceable? Is it not enforceable? It may be enforced in special circumstances. None of the above. It is not enforceable. Then the mind of the maker of the Constitution of India is reflected in which of the following? The preamble. 2017 IAS prelims. How many years does the person of Indian origin need to reside in India to become a citizen of India under the Citizenship Act of 1955? So you have to stay for 7 years in India before you want to become the citizen. You have to register for the citizenship of India. Which country accepted the policy of dual citizenship? United States of America, we have dual citizenship. In India, we have single citizenship. Which article of the Indian Constitution are related to citizenship? Article 5 to Article 11. How many state duties did State Reorganization Commission 1956 suggested? 14 states and 6 union territories. Now, which of the following is not possible by a law of parliament under Article 3 of the Constitution? Formation of new state, alteration of the area of the state, alteration of the boundaries of the state, yeah, admission of new state. Admission of new state will require Article 2. Who among the following is not eligible for registering as overseas citizen of India card holder under Citizenship Amendment Act of 2015? 2015 was the Amendment Act which merges the person of Indian origin and OCI scheme. So a minor child whose parents are Indian citizen are eligible. Spouse of foreign origin from of an Indian citizen eligible. India who migrated to Pakistan after partition. This is not eligible. Then a bill for the purpose of creating the new state in India may be passed by a simple majority in parliament. All this thing we have already discussed, so there should not be any problem in answering these PYQs. So this is all with respect to this video, as this was a revision lecture, and I hope you have revised and all the thing that we have discussed is now afresh in your mind. In the next video, we are going to start with the most important and the heart of the Constitution, that is the fundamental right. Till then, if you are not able to recall what we have gone through this video, so I request you to, before watching the further lectures, just revise the things because revision is the essence of any preparation. Thank you for joining me and watching all this time. Have a nice day.